In the Bryan Kohberger case, when the case and Mr. Kohberger were moved down to Boise, Idaho, a lot of people thought the case would open up a lot less secrecy. Wrong. Things are happening in the Bryan Kohberger case, and one of them is that the secrecy is still there and very much in effect. I'm attorney Andrew Myers, and joining me today is Yolie Medina. Hey, Yolie, how are you?
Fine. Thanks for having me.
I just want to let people know that Lainey is off for the holidays, and she will be back, we presume, for the next episodes, the next series of episodes. But I have the pleasure of having Yolie Medina co-host today. So how's everything going over there in California?
Fine. It's a little chilly, but everything's fine.
So you had actually suggested to me that on this episode, we talk about the fact that Mr. Kohberger had been investigated. Was he really a suspect or a person of interest in a crime that occurred a year before the Idaho 4 crimes? And I rejected it out of hand, but then I realized that that's what everybody's talking about. And so I guess we should too, shouldn't we?
Well, just to be, fair, because, the media put it out there, and I guess one creator got the documents, put it out there. And at first, when I saw that, I didn't think much of it. But after thinking about it, I think it actually helps Bryan Kohberger in some sense.
Well, let's get into it, and then we'll argue about relevance, which is something that, a lot of laymen just take relevance. Well, sure, if it's relevant, it's relevant. If it's not that easy. But this is a story from the New York Post that Bryan Kohberger was investigated over a nearby home invasion a year before the alleged slayings of 4 University of Idaho students. Idaho murder.
You know what? That title doesn't... It doesn't say that he was investigated after the 11/22 crime occurred.
No, it doesn't. Sometimes headline writers in the old days were pithy and they got it all in like a couple of words. This is a long headline and it doesn't really say anything. But Idaho murder suspect Bryan Kohberger was once investigated in connection to a chilling home invasion that took place mere miles from where he allegedly slaughtered 4 college students inside their off-campus housing in 2022, according to a new report. New information about the accused killer comes after ABC News obtained body cam footage of police responding to a suspected home invasion in nearby Pullman, Washington, in October of 2021, more than a year before the University of Idaho students were stabbed to death. I heard my door open, and I looked over, and someone was wearing a ski mask and had a knife, a frightened woman told police. I kicked the SHIT out of their stomach and screamed super loud, and they flew back into my closet and then ran out of my door and up the stairs. The alleged incident, which took place just 10 miles from the gruesome slayings in Moscow, Idaho, happened at 3:30 a.m., the woman told police, adding that the masked intruder was silent the whole time.
Her roommate immediately called the police, the outlet reported, but the case was left unsolved as police were left without a suspect or evidence at the time. The terrifying incident shared eerie similarities with the gruesome quadruple University of Idaho murders. Bryan Kohberger, who is accused of killing 4 University of Idaho students in November 2022, appears at a hearing in Latah County District Court on January 5, 2023 in Moscow, Idaho. Officials said Bryan Kohberger was investigated in connection with a home invasion that took place prior to killing Madison Mogen and Kaylee Goncalves, both 21, their housemate Xana Kernodle, 20, and her boyfriend Ethan Chapin, 20, on November 13, 2022. A surviving housemate later told police she saw a masked man with bushy eyebrows fleeing the house after overhearing cries and sounds of a struggle. Kohberger, a criminology PhD student at Washington State University, was arrested at his parents' Pennsylvania home on December 30th and charged with 4 counts of first-degree murder and 1 count of burglary, charges he has since pleaded not guilty.
That's not really accurate, is it? Because he never pleaded not guilty. He
No.
stood silent. He stood
did.
silent, and then the court, as they're required to do, entered a not. So, whoever wrote this story, I mean, it's an interesting event, but that's not accurate. I'm sorry, go ahead.
Okay. 13 days later, this is 13 days later after he was arrested. It says 13 days later, he was named a person of interest in the Pullman case, ABC reported, but is no longer considered a suspect. So that's where you get your, is this relevant?
Right.
And then it says, we have no reason or evidence to believe he was involved in this burglary at this time. Pullman police told the outlet, citing a height difference between the alleged attackers. While Kohberger is 6 feet tall, the alleged attacker in the Pullman incident was described as being 5'3" to 5'5". The accused stabber was also not yet enrolled at Washington State University at the time of the 2021 incident, the outlet reported. Kohberger stabbed, allegedly, I'll add allegedly.
Yeah. This is a very unprofessional report. It should say, like you just said, it should say Kohberger is alleged to have stabbed.
Well, yeah. Kohberger is alleged to have stabbed the 4 individuals at approximately 4 a.m. in Moscow, Idaho. The case is now closed but remains unsolved, police said. This is poorly written because
it's very poorly written. You're right.
It makes it sound like the Kohberger case is closed.
I know. I thought that too.
Yeah. Okay. Then it says, my family and I have been frustrated that the case was not investigated more in depth or resolved, the victim in the break-in told the outlet. Kohberger's highly anticipated trial is stated to begin in August and last through November.
This is kind of like, do you remember that old Sesame Street song? One of these things is not like the other. I mean, and people get mad at me for injecting humor into these true crime episodes, but I don't know. It was a year before Mr. Kohberger was even there. And no, he wasn't there to scope out the university because he had not, he hadn't, I don't think applied, but he definitely had not gone out there.
Yeah, I believe they checked. The law enforcement checked with the university to see if they had some kind of event during that time at Washington State University where Kohberger might have attended. And they said there was no event. There was nothing. There was no reason. I mean, Kohberger wasn't there.
And so when I initially saw this story, I'm like, why is everybody making a big deal about it? Obviously, and you and I might disagree a little bit about relevance in a legal sense. I said to myself, this has nothing to do with it other than it's a holiday. It's a slow news time, and they brought it up. The crime was never solved, which means that if it happened, and I'm sorry for saying that, but I do say that, the person's still out there. There's a height difference. Although, I question everybody even questioning Dylan Mortenson's analysis as to Mr. Kohberger's height, because there was a step, there wasn't a step, depending on who you talk to. The house is torn down, so I will never know. I don't trust the FBI's LiDAR.
After, it set in, because at first I thought this is ridiculous. Why are they bringing that up? It has no relevance. And it only prejudices Mr. Kohberger because people get it in their mind that, he was investigated for something else. But actually, this actually helps because in thinking about it, there was someone else in that area that broke into a home with a knife and was masked. And it just so happened to be a home where, 4 ladies lived. And this person was never caught. And so if Bryan Kohberger wasn't there, then there could, you could say that in terms of an alternate suspect,
there's somebody still out there. There's somebody still out there.
Yeah. So I would think that the defense would want to use it. Although, it could backfire and turn around to be more prejudicial than probative, because that's the test for, whether something is, even if it's relevant, does it have the chance to unduly prejudice the defendant?
Yeah, I'm going to put you on the bench and say, okay, Judge Yolie, I'm in front of you. I haven't decided whether I'm going to be the prosecutor or the defense attorney yet, but you just hit on it. The definition of relevance for people that don't know or didn't go to law school and didn't try cases, the definition of relevance is which outweighs the other, the probative value of the evidence or its prejudicial effect on Mr. Kohberger. Now, is it prejudicial if there's even a thought in anybody's mind that, yeah, he was investigated for this and he could have maybe been out there and done it? And on the other hand, is it really probative of anything in this case? Does it really, does it tend to prove a fact that is more likely or less likely to have been proven, which is how you define whether something's probative? Yeah. I mean, yeah. How would you rule? Would you let this in or would you not let this in?
Just in terms of what I know now, I probably wouldn't. Yeah. But if there was some argument or in some states, you have to introduce something that you're going to provide the defense of alternate suspect. I don't know what the case is in Idaho, but for the most part, I would say no. But in some cases, if the defense wants to argue alternative suspect, it might go to that. And for a limited purpose, I would let it in terms of, yes, there was another attacker that went into somebody's home with a knife.
So you foresaw my argument. I was gonna put myself now in the seat of the defense, and the defense is thinking, this is reasonable doubt. We got to get this in. There might be somebody out there running around that might have committed another alleged crime, a year earlier. And so we've got to get this in. So now I'm going to go to Judge Yolie and I'm going to argue that this is much more probative of that fact of the alternative suspect. And if you don't let it in, I'm going to preserve that. I'm going to object, and I'm going to preserve that as an issue on appeal. So.
Right. But there's a way to limit it. I mean, you can limit just the fact that somebody who was never caught was going around a year before this crime when Bryan Kohberger wasn't there, that person was out there, breaking into people's homes. So maybe just that alone, not that Bryan Kohberger was investigated for it, keep that out. And then just allow it for a limited purpose in terms of an alternate suspect.
Yolie, do you really think, as two attorneys who have spent years trying cases and reading all of the books behind us in our respective book cases, we can compartmentalize and say, okay, we're going to let that evidence in, but just for that limited, teeny tiny little purpose, and jury, don't take it into consideration for anything? Do you really think jurors are able to compartmentalize like that and distinguish like that? You've heard of jury nullification.
Oh yeah.
And we've talked about this in a previous episode, that jury instructions go on forever and ever and ever. And do you really think, if you let it in for one purpose, do you really think the jurors back in the jury room who want to go home, oh yeah, you can't talk about that for this, you can only talk about, do you really think they're gonna? I don't.
Well, I mean, if that's the only, I think they can, if that's the instruction. I mean, you only look at limited evidence for just whatever the purpose is, to show an alternate suspect. So if the jury could follow that, then that says that somebody else was out there way before Bryan Kohberger was ever in the area who was doing that. And then Dylan's testimony is eyewitness testimony, which isn't always reliable. And then the circumstances under which she hasn't even given testimony, it's just paraphrased by somebody else in the PCA. So we don't know what she's going to say other than what's in the PCA.
No, we don't. And I've always said, and I'll say it again because it's so important, I've always said that the keys to this case, and I'm remaining in the middle. I know there are people out there that yell at us because, you think he's guilty. And there's people that say, oh, you think he's innocent. No, my position is that we don't know enough evidence to really make that final decision. And so, in my view, I think that the keys to this case are Dylan Mortensen and Bethany Funk. I really, and Ashlyn Couch too, because she was in touch with these girls. But
and the 911 call has not been released, so I would like to
yes.
know what's on that, the 911 call.
And what went on during those? I agree 100%. The 911 call, and usually those are released, so it's got to be something significant. And the other thing is that 8-hour delay keeps coming up. No matter what we talk about, we get back into that 8-hour delay, which is just incomprehensible. There was another case just recently, and it was one of those horrible things that happened in New York that, a small child had called 911 when they saw something happening. And so why didn't Dylan Mortensen, or if Bethany Funk was home, and I don't know. Let me know what you think about this, but I'm not 100% sure that Bethany Funk was even home. She got home, and then when the police showed up, she was there, but I'm not sure that Bethany Funk.
I'm not sure either, because it says that when they arrived, Bethany was there. It doesn't say she was there the whole night.
Right. So I have my own suspicion. But anyhow, I mean, so that's a huge, you bring up a good point, the 911 call, what happened, who made it, and what was said, and then the 8-hour delay. God knows what happened in those 8-hour delays, which brings us to the next subject. Was there a confidential informant that came in and went into the house and checked things out that we don't know their name? And I believe that the answer to that question is yes. And we've talked about this before. I think the answer to the question is yes, there was absolutely a confidential informant. And this came up kind of recently, and I don't agree with the context in which it was brought up. But here is a motion, a stipulated motion to seal the state's motion, a motion for a motion to extend the no contact orders and amended no contact orders. And I guess some people that are newer to the case saw this. The reason coming out of the state of Idaho by and through the Latah County prosecuting attorney, and hereby moves the court pursuant to Idaho Court Administrative Rule 32G1 and Idaho Code 74-124 for an order sealing the state's motion to extend no contact orders and amended no contact orders, which is a whole interesting subject in itself, which we're not going to dive into in this episode. And they want this motion because release or disclosure would, and anytime you bring a motion, you have to tell the court why. What are your reasonable grounds? That's the legal touchstone. What are your reasonable grounds? And so this is a cut and paste we've seen in I don't know how many motions before.
It's misnumbered. It has 2 2s. It's always had 2 2s, and they don't correct it.
And that's how you can tell it's a cut and paste, because how many motions have we seen? The 1, 2, 2, 3, 4. They just cut and pasted, and nobody catches it. But anyhow, number 3 or number 4, depending on how. Number 3 is disclose the identity of a confidential source. Well, they've been saying that in every motion, and somebody somewhere along the line took it seriously this time, and they've brought up all the conspiracy theories, the Kopaka theory, the other theories. But this dates, and there's Bill Thompson. I had predicted that his influence over this case would be waning, but once again, I wasn't totally correct. But we go all the way back to a state's response to a request for discovery way back much earlier in the case. And one of the requests was, we want to know about the informant because, the defense needs to know about this. But look at number 10. To the extent that information exists regarding an informant who is not going to be produced as a witness, including recordings or written statements of an informant or that identify an informant, such information is not subject to disclosure, and the state asserts informant privilege under Idaho Criminal Rule 16G2 and prays for appropriate protective orders pursuant to ICR 16.1 as necessary. So I remember very early on putting this in context to some other things that were going on. I think that comes right out and says that there is a confidential informant or informants because, and you may or may not agree with me, and we didn't talk about this in advance, but one of the rules of pleadings is that you should either admit or deny a request like this. And if you deny it, it has to be in good faith. So they couldn't just deny. And so they did not admit that there is an informant and deny the request on that basis. And they didn't deny it. So my reading of that was, yes, there's an informant.
So when you have these confidential informants, I mean, the accused has a right to confront his accusers, right?
Yes.
That's the confrontation clause. So
Yes.
when there is a confidential informant who's ratted on you or who has said something that they saw you do the crime or something like that, how does that work with a confidential informant? I mean, at some point, doesn't the accuser get to confront him on that?
My informed guess, and that's all it is an informed guess, is in all this discovery that has been sealed, it's in there. My guess is that it's in there. I can't imagine, based on what you just said, that they would not do that. And if it's not in there, it will be disclosed when the witness lists are due out. And I forget when the witness lists are due out. I don't know if it's April or May. I can't remember, but it is in the spring.
Yeah, because the number 10 in front of us says, to the extent information exists regarding an informant who is not going to be produced as a witness, who's not going to be, I would think they would be, that's what I have trouble with when they say there's a confidential informant who isn't going to testify at trial. How do they get around that?
That's a good point. I think that's a really good point, because like you said, that under the confrontation clause of the U.S. Constitution, I don't care what Idaho's law is.
Right.
Anybody that is accused of a crime in this country has a right to, examine all the evidence. So I don't know, and I don't care what the Idaho rules say. I mean, I've been through them, I've read them, we've talked about them in some previous episodes. I don't care what Idaho says, because that's a federal law. That's the U.S. Constitution. So I don't know, Yolie. My guess is that they would have provided this in some of these sealed documents, because
that the person remains confidential, but only the defense knows who it is.
And nobody has ever said anything definitively. Yes, I've heard 3, I've heard 6, I've heard 5, I've heard 4. So comment down below all you want. Tell me I'm wrong, but give me a citation to anything that says how many people were standing outside of that house at 1122 King Road when law enforcement got there at noon on November 13th of 2022. I don't recall anybody giving a definitive number of people that were out there. There are people that have said, people went inside and, they were shocked and they came right outside again. So, plus who all was in the house. I mean, it was a party house, which I've said means drugs, and people get mad at me for saying that, but it does mean that. And were there neighbors up because it's a college town? They have pictures of people wandering around on one of the streets behind there. They have not the, they say it's the Elantra, but in my mind, it's an Elantra. So right. I don't know. Yeah, I really don't.
Very interesting.
So there has to be a confidential informant, I would think.
It's starting to seem that way more and more.
Yeah. Okay. Final thing here. Do you remember that some time ago the court indicated that people could provide a request to unseal sealed information?
Yes, and I was waiting to see what happened with that, because I know that you hadn't received a response, and it was a while.
Well, I get so much email that I don't know about you, but I get so much email that sometimes it blows right by me and I don't see it, and I get embarrassed. But so I actually wrote to the court and I said, hey, I requested some information way back in October and I haven't gotten it. Did you not get around to it? Or did you not allow it? And so here it is. Get out the dun, dun, dun. Here we go. Mr. Myers. Please see attached your request to inspect records, which has been denied by Administrative District Judge Hippler. Thank you. If you have questions pertaining to the attachments, please contact me by responding to this email. And I'm not going to dox them, but it was sent by Carrie Maxwell, Trial Court Administrations, Ada County Courthouse. I'll credit them. I just sent my request as to what had happened in the morning that we are recording this episode, and she got right back to me. I was eating my lunch, and there it was. So you know what? Have you heard of any other? Because I know a bunch of other people have talked about making their requests. Have you heard of anyone actually getting material?
No. And what I have noticed, though, is that it's taking longer for documents to get on the docket.
Yes.
And I think the judge is, and I don't know this for sure, but I think the judge is reviewing everything before it gets posted. And that's why it's taking so long, because I think the judge does want to review everything to see if it really needs to be sealed. I mean, if it should be out in the public. And at first I thought that maybe he was going to be more open about it, but maybe now he's scrutinizing more and going through the documents to see if they should be posted or not.
Well, that's a good idea. I hadn't even thought about that, but that's a good thought that maybe he is screening the stuff more carefully. But at the same time, it seems like almost everything is a request to seal it. And it seems like it's joint, that both parties, I mean, if it's the prosecution doing a motion to seal, the defense agrees. And if it's the defense filing a motion to seal, it's almost like, they have that level of amicability here, that they're working together and they agree on that. But I don't know. This is a question for our viewers. If you have heard of any other creator or anyone, I mean, our viewers can request material. If you have heard of anybody getting material, let me know. And we don't want to step on anybody's toes. I won't ask you for the information, although I'd love to see it. But just let me know if you know of anyone since mid-October. I think it was October 11th or right around there that the court said, here's a procedure to get information that's been sealed in the past. Here's the form to fill out. And here's the email that you send the form in on. And I did all of those things. And as far as I know, no one has gotten a positive response. And there's my dear Attorney Myers, denied. So I'll admit that my request may have been a little bit broad. I wanted discovery materials, and I wanted a lot of them. Well, why not?
Yeah, I mean, if there's an avenue to request, and it does force the judge to look at the request, because it forces them to look at it and to see if it's something that's really, really needs to be sealed. But I'm beginning to think now that like you said, I'm beginning to really think now there's a confidential informant, and things are sealed because possibly there's another investigation going on a different matter. I don't know. I have no idea. I'm just speculating.
So my guess and speculate, as long as we're speculating, my speculation is that they denied my request because it was too broad and I asked for a lot of stuff. So I'm trying to think in my mind as time has gone by, I've thought of other things that I would request, but I didn't, for example, the affidavit behind the Franks motion,
right,
some of the other affidavits. So and I am going to make another request, but I'm trying to think how to narrow it down to certain things. And there's just so many things. I mean, you and I could sit here for the next 5 hours, probably. And we're not going to, but
there are people who do sit for 5 hours and talk about it.
Well, we could, I know, and I can't stand it, but what I was going to say is you and I could probably sit here for the next couple of hours and make a list of all the stuff that we'd like to see, because we have curious legal minds. But what I'm trying to come up with is what specific items people, I mean, tell me if there's any specific you'd like, but I'll ask our viewers and commenters.
The 911 call.
You know they're not going to allow that.
Yeah,
they're not going to allow that. Well, maybe we should ask it. Maybe we should ask for it.
Because here's the thing. How did a confidential informant call it in? They didn't say that a confidential informant called it in. They said one of the ladies that either they used Dylan's phone, somebody called it in. They didn't. It was one of the people that were there with a group of people at the house in the morning. So they didn't say a confidential informant called it in.
No, they did not. You're right. And I believe the call was made from Dylan's phone. How about for the names of the people who were outside of the premises when they got there? How about an inventory? Now, sure enough, we got inventories of what they found at Mr. Kohberger's Wrightsville, Pennsylvania home, what they found in his office at Washington State University, what they found in his apartment, what they found in his car. To my mind, those are the only inventories I remember. What about an inventory of the stuff that they took out of there a couple of weeks afterwards when Chief Fry drove the U-Haul truck into the driveway and the cops, remember that?
Yeah.
Do you think they ever inventoried that?
I don't know.
Well, shouldn't they have?
And yeah, we're like, they allegedly took out the like furniture, all kinds of things out of the house, and they allegedly returned it to the family.
Parents.
I thought. The parents, right?
Yeah, but I mean, a comment was made by someone above my pay grade who knows a lot about investigating crimes. Shouldn't they have allowed the parents to go in there? Yeah, it would have been a horrible thing. It would have been a shocking thing. It would have been a terrible thing to see. It would have been an awful thing to see. But at the same time, as an investigative device, shouldn't the parents have been able to go in there and see, if there was anything that was not property of their kids? I mean, who knows kids better than their parents? Shouldn't parents have gone in there and said, that's out of place. What about this? And I've always said that I can't believe that, 4, 5, 6 college students didn't have some smart device that would have or could have captured all this stuff. I've never believed that because, I know young people that, they carry their stuff everywhere. They have refrigerators that talk. They have microwaves that take pictures. So I would like to see an inventory of stuff that was carried out. But seriously, to my viewers and commenters, if you have a specific kind of request that you think I should make, let me know and I'll do it, because I do want to request more material. And I'm not being repetitive or harassing. It's just that, I think if the court took this step of saying we're going to review stuff and we're going to disclose stuff and stop all the secrets, I want to participate.
Yeah. And I wonder if they took a list of names of all the people who were there in the morning.
That's what I'm saying.
Yeah.
That's because that's standard police work. That is standard. If they didn't do that, I mean, my objectivity is going to fly out the window, because that's one of the things that you do in police work is when you get to a crime scene and there's people standing around, first of all, you seal the crime scene and you take an inventory and get the identification of all the people that are standing around. That's number one. And if they didn't do that, my objectivity is going to fly out the window, if it didn't already.
Well, I know that one of the responding officers, I can't remember his name, but he saw all the people and he's in his mind thought, I know we're going to need help. So I don't know how many people were there, but
Yeah. So anyhow, interesting stuff. So I guess my closing thought is I would like to see the secrecy go away. And I had initially thought when the case was transferred down to Moscow, Idaho, I had initially thought, geez, all this secrecy is going to go away. And there's a new judge. It's going to be a new day. And I said that in those words. And I don't want to eat crow. I want to think that, maybe that's going to happen because, people do have a right to know. They really do.
Yeah. And perhaps the judge is just looking over everything to see. I mean, why put the request to inspect sealed documents? Why put out that form? If, I think it's a review for him. Like if somebody requests something, he can review it and decide, should this not be sealed and be available.
Well,
but
I would think
they'd have to have a hearing about it, I'm sure.
I don't know. I would think, and maybe I'm wrong again, I would think that this court has, assistants, interns. In the Sarah Boone trial, every day when Judge Cranick came out, there were, I think, 3 young people that came out and sat behind Judge Cranick, and they were interns. They were legal interns. I mean, I'm sure when you got out of law school, you had a similar experience that I had, that, people start out as court clerks, which is a whole different category. And they basically, as a court clerk to a particular judge, they tail the judge. And then the judge gives them stuff to work on.
Mm-hmm.
So I would hope that Judge Hippler and the 4th District court in Ada County in Idaho would have assistants that can pour through all of that stuff.
Yeah.
I mean, for one person, especially a judge, because he's got other stuff to do. He's got to sit and deal with what other kinds of things come before him. But I would think that he would have other people that can go through it and divvy it up. You take this, you take this, you take this, get back to me in 3 weeks.
Yeah. I mean, you never know, but anyway, this is an interesting case. There's so many aspects to this case that you could just go down one subject and go down a rabbit hole.
Yes.
But going back to that article, I'm going back to the information about Bryan Kohberger being a suspect in the prior invasion. I think it's just prejudicial. I do. And I think that it could help Bryan Kohberger if his attorneys finagled a way to make it work under the alternate suspect theory. But just putting it out there like the way it was is just, articles being written about it. They give the impression that he's been involved in something before. Oh, I just know it. I know he is. And that's not good.
Yeah, but the facts are so weird. The facts are, it's true in both crimes. Allegedly, there was a knife involved. It's true that in both crimes, allegedly, it happened in the 3:30 time frame, although that's controversial. But if it happened a year before, and one little comment that I didn't make, and at the risk of getting all kinds of negative comments, the police in the previous incident said there was no proof, there was no evidence, there was no DNA, there was no evidence that anybody had even been there. So I'm not going to say that the person made up the report. I'm not going to say that, but that fact is there, that there was no evidence. Of course, with Mr. Kohberger and the Idaho 4, what we've been told allegedly is that, there was nothing at all in his car or his apartments, and there was just a little bit of touch DNA on the knife sheath. So I don't know. If I were the judge, I put you on the spot before, so I apologize.
That's okay.
If I were the judge, I think I would not allow it.
Yeah.
I think it's more prejudicial, but I think it's irrelevant. I just think it's totally irrelevant. I don't think it's relevant. Now,
it does have the potential to prejudice, and only a very good defense counsel, I think, could use it, or just if they're going to use it for a limited purpose and be able to argue that. But it is risky. I mean, I don't know.
Yeah. Well, Ann Taylor has shown her ability to be very, what's the word I'm looking for? Prolix. She's been able to write 13, 14 motions at a time. So let's see what they do with it. Let's see what they do with it.
There's a new document on the case summary. It hasn't been published yet, but it's a subpoena for records.
What kind of records?
We don't know. It hasn't.
Oh, okay.
It just showed up on the case summary. It hasn't been put out for the public yet.
Oh, you mean while we're doing this episode?
Yeah, just recently. Yeah.
Oh, good grief.
Yeah, but I don't know before.
Any closing thoughts? Oh, wait a minute. We didn't do our comments. So
okay. This is Storm Dancer 859. Question: how can a seizure of items be limited to something if you don't go through everything to see what applies? Good question.
It is. Yeah. This goes back to an episode we did a couple of weeks ago about all those motions to suppress, and the argument that was made that they have to be narrowly, sufficiently tailored to not violate the defendant's privacy rights under the Fourth Amendment. And I mean, how do you answer this without, kind of in a vacuum? You can't.
Yeah,
you can't just say, I'm going to go into somebody's house and pick everything.
It has to be reasonable. I guess the search has to be reasonable for what you're looking for. Like if you're looking for computer files, well, okay, you go to the computer. You're not going to be looking in their underwear drawer. I mean, you know what I mean? It's just, it has to be reasonable. So
didn't Karen Reed made a comment that they went through everything but they went through her sock drawer, but they didn't go through, whatever. So, but then the issue is, what about a computer? You just mentioned a computer. What about a computer? Can you just say all files in a computer? Or do you have to delineate?
I think you take the computer and then I don't know. I really don't know.
I'm stumped on that one too. And the reason I'm stumped, and I mentioned this before, in New Hampshire, there was an attorney who was convicted of unaliving his wife and burying her up in Maine. And several years later, he stopped paying off his son, allegedly. And the son got mad and told law enforcement where the body was buried. So now he's an attorney. And of course, the prosecution would have wanted to go into his computer, I would think. But what about all the confidential client data that he had in there? Because I do bankruptcies, and I have people's personal information. I'm not going to get into it, but because I just don't. But I have all of their personal financial data in my computer. So how does law enforcement dance around that? And I don't have the answer to the question. This is a law school bar exam question. If an attorney is suspected of a crime, and this guy was convicted, he's serving a life sentence. How do you word that warrant for the computer? You can't just. Can you say we want everything and we'll not disclose the client data? Can you say that?
I don't know. I would think that the entirety of the computer would be taken, the computer, and then it would be subject to some kind of forensic examination. But I would think that if that's the case, the defense attorney, whoever's defending the person whose computer is being seized, would have to say, wait a second, we need a protective order. We need to make sure that the judge sees what can be allowed forensically examined and what not. But it seems like a very complicated procedure to me, because how that is a very good, maybe it's somebody who's a police officer or a forensic person can answer that.
Or a judge. I think Storm Dancer came up with a good question, and I apologize. We don't have a precise answer, but a lot of things in the law are like that, right, Yolie? A lot of things say it's got to be reasonable. So that's a question for the courts to determine what's reasonable. I think it's got to be, reasonably narrowly tailored. That's the answer to the question.
And, I just thought about it. Now, if they're looking for any type of computer stuff, I mean, maybe they might suspect that they have a little one of those little drives.
A remote hard drive. I have one of those. Yeah,
portable hard drive stuck underneath the drawer in their underwear drawer. So maybe they, you know what I mean? Maybe they want to go and check and touch the, I don't know.
No, but good point. Good point. Excellent.
I have no idea. That was a very good question.
It was a good one. We have some sharp viewers here. So the next one is from I'll do it when pigs fly. I'll do it when pigs fly. I don't know. I think it's all very clever. Ann Taylor mentions just about everything in most of the motions to suppress. I read them all. It seems to me like if she can even get one suppressed, a lot of evidence gets suppressed also. I also think she's been dismantling the case piece by piece. It sounds like a game of chess to me. It's very strategic, and she's setting herself up for a massive checkmate. I don't believe BK is guilty.
Interesting.
Yeah, we get some good questions.
Yeah, and, this is I mean, most attorneys, that's how they work. They have a strategy.
Yeah, and you have to bring these motions in a criminal case. If your if your client is charged with a crime, they've got to prove each and every element of each crime. And, each crime has, 3 elements, 5 elements, 6 elements, 2 elements, whatever. And so it is actually grounds for malpractice, I've been told. It is also grounds for a motion for an appeal based on ineffective assistance of counsel if you don't bring these motions. Did she go a little bit overboard? I don't know. They want to put her client in front of a firing squad. So I tend to think, no, she didn't go overboard. And to people that say they're delaying the trial, we did a slide a long time ago of the amount of time it takes various cases to go from the time of the crime to trial. And this case is right in there. I mean, it's not like a minor thing. So I don't know. I don't think she's doing anything wrong. I really don't. This one's yours.
Okay. Leah Ever 777. If I was accused of this horrific crime, I would have pleaded not guilty. And I would not be as comfortable as BK is staying in jail. In my opinion, his defense is going round and round and is only stalling. Only reasons for that is 1, he's guilty and defense will keep stalling, or 2, defense knows if they keep this up, BK can claim insufficient counsel. Just because we are privy to some evidence doesn't mean we are privy to all evidence.
Well, that's true. That
true.
part of it's true. And also, defense knows if they keep this up, BK can claim, I think what they mean to say is ineffective assistance of counsel.
Yeah. And then as far as BK being comfortable, I don't know how comfortable he is, but there's nothing he can do. He didn't get bail, so.
Yeah, and when I was in graduate school, it was a pain in the neck, but I don't think I would have rather have been in the state pen.
Right.
I shouldn't laugh because people give me, oh my gosh, I should have read this one comment we got. Oh, I don't like when you laugh. I don't like when you giggle. This is serious. And it's like, all right.
Well,
all right.
It is, but sometimes, you got to bring light to something.
Yeah. So do you have any closing thoughts?
No, I just what I said before about the new information.
Yeah, me too. And I do want to encourage our viewers to go ahead and tell us if you have any ideas for things that I will do another request.
Mm-hmm.
But I want to calculate it. Maybe my previous request was too broad. I'll give them that. But I want to, there's just so much. So let me know what you feel that I should, in a calculated manner, request.
Yeah.
All right, Yolie, thank you so much for joining me. Thank you so much for sitting in for Lainey. Appreciate it. And folks, Happy New Year. Have a good one. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.